In this video, I want to do a brief discussion of the UK's definition of terrorism. It's been in the news recently, so I want to explain what this definition is, how it operates in practice, and how it confers a significant degree of discretion onto decision makers, such as the Director of Public Prosecutions and the police. We all probably have a basic understanding of what terrorism is. There may be some event that comes to mind that you think of when you hear the word terrorism. So most likely it's going to be something like 9/11. For other people it might be things like the conflict in Northern Ireland and the Troubles and the different paramilitary groups that were involved in that conflict. Or for others still, it might even be things like the so-called Islamic State. Some individuals, when they hear the word terrorism, they might actually think of state actors and the idea that a state's army might commit acts of terrorism. Really what terrorism is, as a basic understanding, is illegitimate political violence. So that word illegitimate is important because it suggests that there is something wrong about terrorism. It also suggests that there are forms of political violence that are perfectly acceptable. Of course, that's going to raise a lot of questions and a lot of debate about the distinctions between the two. So, for example, do we think that only states can commit legitimate political violence? Only states have a monopoly on violence, so only states can use force legitimately. But that raises the question, are there instances in which states cannot use force legitimately? And this might push us into the area of international humanitarian law. And we come to discussions about things like war crimes and crimes against humanity, or basic breaches of the laws of war. When we go down that road, that raises the question as to whether we actually need to describe these acts as terrorism, or can we not just call them things like war crimes or violations of international humanitarian law? Why would we need to call it terrorism? Conversely, does this mean that any political violence carried out by a non-state actor is automatically terrorism? It's illegitimate. Non-state actors can never commit legitimate violence. That raises the question then as to whether we can ever have freedom fighters. Or are all freedom fighters terrorists, regardless of the government against which they are directing their attacks against? Really, what this idea of terrorism does, it actually tells us as much about the person using the label as it does about the thing that they are describing. It's for these two reasons that we don't actually have an agreed upon definition of terrorism in international law, because states disagree upon these issues. And a state's perspective on this debate tells us a lot about a state's own experience with these forms of political violence. But simply because we don't have a definition of terrorism in international law, that doesn't mean we can't have a definition in domestic law. There's nothing stopping that state from incorporating into its own domestic law its own definition of terrorism. And that's what the UK has done with Section 1 of the Terrorism Act 2000. So if you look at this definition, it's quite long and it's quite detailed. But really, for the purposes of our discussion, there are two key parts of this definition that we need to focus on. They are the definition of what constitutes a terrorist act and the definition of motive. So we can see in this definition that a terrorist act is one which involves serious violence against a person, or it could be one that involves serious damage to property. It could be one that endangers a person's life other than that of the person committing the action. It could be one that creates a serious risk to the health or safety of the public or a section of the public, or it could be one that is designed to seriously interfere with or seriously disrupt an electronic system. Not only that, the definition also covers threats to do these things. So it's not just the act itself, it's threatening to do an act as well. Now, not every act that involves violence against a person or serious damage to property constitutes terrorism. If that were the case, then almost any crime would amount to terrorism. Instead, what's key to that is this notion of motive. It's this political dimension to the definition of terrorism. And motive then is defined in section 1 that the use or threat of an action is designed to influence the government or international government organisation or to intimidate the public or a section of the public, and that the use or threat is made for the purpose of advancing a political, religious, racial or ideological cause. There's also a further clause in this definition that says that if firearms or explosives are used, we don't have to prove that it was designed to influence the government or to intimidate the public, so long as it's done for a political, religious, racial or ideological cause. So there's a little carve out in that definition there. But needless to say then, this definition is incredibly broad, even with that requirement of motive. It raises the question as to whether many forms of protest could fall within that definition of terrorism. So for example, let's say if a protest creates a risk to the health or safety of the public, say if it involves the blocking of a road or the blocking of certain forms of infrastructure, could that constitute terrorism? What about a form of industrial action? Industrial action is designed to be disruptive. And so you could be disrupting or interfering with certain infrastructure, may even be a risk that that disruption or interference could create a health or risk or danger to the public. Does that mean that these fall within the definition of terrorism? And this is where we're seeing a lot of debate today. What are the limits of this definition? Legally speaking, a lot of forms of protest can satisfy this definition. But what Parliament has done in defining terrorism this way is it's essentially placed a lot of trust in the discretion of decision makers who have powers to exercise their discretion very carefully when deciding whether to apply counter-terrorist powers or not. Now, the definition is broad because Parliament has decided that it needs to capture the lowest common denominator. We don't want to allow certain forms of action to escape this definition. And then the decision maker discretion comes into play to filter out what to prosecute, what not to prosecute, who to arrest, who not to arrest. Now, relying on discretion is very problematic from a rule of law perspective. By which I mean that individuals are able to conduct their behaviour with reasonable foresight and reasonable belief that they're not going to be breaching the law. And the Supreme Court has called out this reliance on prosecutorial discretion. The Supreme Court has said that this is illegitimate. Ideally, Parliament should not have done this. But the Supreme Court also said that there was absolutely nothing that it could do about this. And so we're stuck with the definition that we have. And lots of things that can legally satisfy that definition of terrorism may not actually be treated as terrorism by the various decision makers. But again, putting that trust in these decision makers raises a lot of challenges from a rule of law perspective, and can be very worrying, because ultimately it's not the law that's really protecting us here, it's the decision maker discretion. Now, the UK definition, on the face of it, makes no distinction between good freedom fighter and bad terrorist. Now, that's because the definition, when we talk about an act that's designed to influence the government, the definition of government includes other governments in the world, not just the UK government. The courts have also held that that can include governments that are non-democratic, potentially authoritarian or tyrannical governments too. And so any act against those governments can also potentially satisfy that definition. Terrorist, the definition as well applies to acts not just in the UK but abroad as well. So what this means is that if you're a British citizen or resident in the UK and you commit an act that is potentially terrorist overseas, you can be prosecuted for that in the UK. Now, this issue has come to the fore in relation to overseas fighters in places like Syria who have returned to the UK, and decision makers, the Attorney General and the Crown Prosecution Service, are trying to figure out whether to prosecute an individual or not. And the UK's definition of terrorism essentially means that any organisation in Syria that was fighting against the Assad regime, even if that organisation was democratic or was fighting for a democratic liberal Syria, as opposed to, say, the so-called Islamic State, even if that organisation is a pro-democracy organisation, they are still potentially committing acts of terrorism, and they are still potentially liable for prosecution when returning to the UK. And actually, several trials have collapsed as a result of this. In 2015, for example, a trial collapsed when it was found that the individual was fighting for an organisation that was being backed by the British security forces. So we have this strange situation whereby the UK could be giving active support to organisations that satisfy its own definition of terrorism. And it's discretion of decision makers that's coming into play to filter out whether to prosecute or not to prosecute. But this means that there are lots of individuals, say, who've travelled back from Syria, and it's unclear for them at the time that they have done that whether or not they will be prosecuted for committing an offence. So on the face of it, it looks like the UK's definition of terrorism doesn't make a distinction between good freedom fighter and bad terrorist, but in reality, it's the decision maker discretion that's making that distinction. In fact, the UK's definition is so broad that it potentially even applies to state actors too. And the independent reviewer of terrorism legislation, David Anderson, pointed out that the definition could even apply to the UK's own armed forces. Again, it's decision maker discretion that's filtering out those potentially absurd applications of the definition. But it's not the legal definition itself. But what all this reliance on discretion reveals is actually when the police are saying that they're merely applying the law. For example, in relation to certain protests, they're suggesting that they do not have any choice. In reality, they do have a choice. In reality, it's discretion that plays such a key factor in ensuring that the definition is not applied to rather perverse or extreme examples. The police always have discretion. This is why the notion of zero tolerance policing is a complete nonsense. Discretion is always used, and discretion is integral for the system to operate fairly in the first place. So discretion in counter-terrorist powers and policing is incredibly important in certain areas, for example, like in Northern Ireland. So one counter-terrorist power that has been in the news recently is proscription. So this is where the government declares certain organisations unlawful, and then certain offences can flow from this. For example, declaring your support for this organisation. Now in Northern Ireland, the prosecution of proscription offences is a very, very sensitive area. And the police exercise their discretion all the time in terms of deciding whether to prosecute or not. So for example, if you go to Northern Ireland, very often you will see a mural on the side of a building, or you may see flags that expressly refer to certain prescribed organisations. Now the police know about these, but they don't take the decision to prosecute. Why? Because ultimately policing is about trust, and it's about support, and it's about what is operationally possible. Should we use our resources to do this? Would this cause more harm than good? And so discretion is really important in Northern Ireland to ensure that these powers, when they are actually used, are used in circumstances where the police consider it absolutely necessary. So you can see how discretion can result in a very different form of policing and a very, very different form of application of the same laws in different parts of the UK. So in conclusion, the UK has a very, very broad definition of terrorism. And this is designed to capture the lowest common denominator and to make sure that certain things do not fall through the cracks. But in reality, this confers vast discretion onto decision makers like the Director of Public Prosecution and the police. As a result of this, decision makers need to exercise those powers with caution and not apply them to every single instance in which the definition of terrorism is legally satisfied. As I've mentioned, one of these powers is proscription. If you're interested in learning more about this power, I've uploaded a video regarding the recent proscription of Palestine action, where I talk more about the definition of terrorism in that context. And if you want to watch that video, you can click on the link on the screen.